We're live.
Okay, great. Good morning. This is Senate Judiciary on March 18th, and we're here with a confirmation of Judge Waples.
Waples.
May.
I answer to anything.
As a Supreme Court Justice in the state of Vermont, which we're honored to have her honor with us. And maybe our normal fashion is for Judge Zonay to introduce folks. So take it away, Judge Zonay.
Well, good morning. Tom Zonay, Chief Superior Judge. It's my pleasure to be here today with this committee to introduce Judge Nancy Waples for the position of Associate Justice on the Supreme Court. As her application that you've received indicates, Judge Waples attended William & Mary for undergraduate school and then St. John's Law School in New York. After graduating, she worked for 28 years as an attorney. She began in as an assistant district attorney in New York. She worked in private practice. She's been an assistant United States attorney here in Vermont and spent many years also in private practice here in Vermont. Her application details her diverse and impressive professional and civic involvement, and it also details her personal and family history. I would note that I don't think it details something that is also very important to Judge Waples, and that is that she's married. Her husband is an assistant U.S. attorney here in Vermont, and she has two sons who I think are watching us here today, possibly.
They are, yes.
And her sons, I would note, are also studying to be attorneys. So mom and dad's impact on them has been significant.
Wow.
I would tell her sons they should be proud of her mom, but I have a pretty good idea they already know that. From her interest in the law being sparked by her father and his studying to be a citizen and her assisting him with that when she was in high school, to the lessons she has learned from her mother of empathy, compassion, respect, and kindness, and to personally feeling the sting of racism at different times in her life. Judge Waples has a very diverse, informed, and inspiring personal history, which has made her the exceptional person, leader, and jurist that she is today. She has served the citizens exceptionally well as a trial judge for the past 6 years, and would no doubt do the same as a member of the Vermont Supreme Court as an Associate Justice. It is with great pleasure that I introduce Judge Nancy Waples.
Thank you. Thank you, Senator Sears, and thank you, Vice Chair Baruth and committee members for the opportunity to appear here today. Thank you, Chief Superior Judge Zonay, for your kind introduction. And thank you, Governor Scott, for the tremendous honor of the nomination. I am humbled to fill the seat of Justice Beth Robinson, who served with distinction prior to her elevation to the Second Circuit Court of Appeals. With me here today in our virtual hearing are my wonderful husband, Greg, and our sons, Lane and Graham, who bring us great joy each and every day. My loving and always supportive sister, Eileen, and her husband, Drew, also join us. I've spent my career as a trial attorney, as a trial judge, a trial attorney, and appellate attorney. As a lawyer, I primarily practice as either a prosecutor or criminal defense attorney on both the state and federal courts. Because I am accustomed to arguing both sides of a case, I have learned that most cases have strengths and weaknesses. As a judge, this has taught me to be fair and open in my judgments. Law for me is not partisan, and I am deeply, deeply committed to the rule of law. I love my work as a judge because it allows me to serve the public interest and to perform justice in individual cases. That has given me the opportunity to learn other areas of the law and to work in different courthouses throughout our great. I have now served on every docket in the judiciary. I have also served in 8 of the 14 counties of Vermont. I have come to know the communities where I've served through the parties, the attorneys, and the judiciary staff who day in and day out perform their jobs with dedication and grace, often working with folks who are going through the most difficult time of their lives. Each day, I strive to treat with dignity and respect every individual who comes into our courtrooms. I am committed to making sure parties feel heard, and regardless of the outcome, leave the courtroom feeling that they have been treated fairly. I am proud if those who have appeared before me have that same perception. I am deeply grateful for the growth this job has given me, and I believe I have worked hard to meet those challenges. Currently, I serve on several committees within the Vermont Judiciary that focus on policy work and strategic planning. That work has given me a broad perspective of the judiciary, and it is complemented by my day-to-day work as a trial judge. It has helped me to identify and strive towards addressing issues to promote the fair and efficient administration of justice in Vermont. An appointment to the Supreme Court would give me an opportunity to serve and dispense justice in new and different ways. The duty of a justice is, of course, to apply the laws that have been written by the Vermont legislature, the Constitution that has been adopted by the citizens of Vermont, the body of jurisprudence contained in 230 years of Vermont reports, and the Constitution and laws of the United States. However, it is equally the duty of a justice to interpret those laws and constitutions. Indeed, it is an extraordinary responsibility, and I cherish the opportunity. I have now called Vermont home since 1991. I have witnessed with pleasure Vermont's increasing racial and ethnic diversity. My life has been enormously impacted by growing up in two very different cultures. My parents are immigrants who fled the Communist Revolution in China. I grew up working side by side with my three siblings and parents in our Chinese restaurant to earn a living. I grew up with the dust of honest labor on my hands. My father and my late mother faced many challenges with great courage and integrity so that their children could pursue their American dreams. My parents instilled in me a deep appreciation of how fortunate I am to be an American. I believe I will bring a different perspective, a personal perspective to my job. And of course, judicial decisions depend on facts and relevant case law, not on personal viewpoints. However, justice does not just come out of law books. Its inspiration is the individual spirit and the human soul. It would be the highest honor of my professional life to serve Vermont as its next Associate Justice. I thank you for considering the nomination, and I welcome your questions.
Thank you. Thank you very much.
Yeah.
Very impressive, and I'm sorry you can't see our full faces because of the mask. But
I do appreciate the comment, though. Thank you, Senator.
Required. It does lead me to a couple of questions that I have. The Supreme Court is unlike other courts in that you're forced to make decisions with other justices.
Mhm.
And can you talk a little bit about your ability to work with others within the court system,
Sure.
making decisions and reviewing case law and so forth?
Certainly. Well, I've always enjoyed the collaborative effort. I believe I work well with others, and I have a deep appreciation for collegiality. It's always been my practice to work as hard to achieve consensus whenever possible. That was particularly important during the pandemic, and I was a presiding judge in Lamoille. And I had to work with staff, attorneys, stakeholders, parties, litigants, to make sure that our courtroom could keep running and we could keep providing access to all who needed the help of the court. But I understand the very different role of a trial judge from an appellate judge. I think often, usually, with the exception of presiding on family cases with the assistant judges, who are always very helpful in helping the court as finders of fact. By and large, the decision of a Superior Court judge is more or less independent in how to rule regarding a certain controversy. In the appellate court, of course, you're one of 5. And in my mind, it is extraordinarily important to seek unanimity on decisions, because that will promote more certainty and guidance to the parties. I think it's really important for people to have to check their egos at the door and to really work hard with each other to achieve a result that will give more clarity to all the parties who are seeking a novel answer from the Supreme Court.
Thank you. It's very helpful, actually. The other issue for me is that oftentimes the Supreme Court, and when I was first elected and served on the Judiciary Committee and the Appropriations Committee, I was often surprised to see Justice Dooley come into the Appropriations Committee to present the Judiciary budget. And so you have that role as well as an administrator. I think it's divided up, but I'm sure you will handle that well as well. I see that your husband is on the Zoom, so if they would like to appear, and I'm hopeful that they are all in concert and support your new role.
I think they are. Yes, definitely.
If you'd like to turn on his video, we'd be happy to say hello to him.
Oh, yes. All right, certainly. So I see Lane. Did you want to turn on your video, dear?
Lane's her son.
So Lane is my son, and he should be.
I guess he's shy.
Is he shy? I think
Hi, everyone. Thank you so much. I am actually in school right now, and
class.
A bunch of people. So thank you very much. And it's a pleasure to hear you all. And Mom, you're doing great.
Well, thank you. It's good to know that the family supports the nomination of the judge.
Yeah, and then my husband is over here.
Oh, good.
Oh, okay.
Good morning, everyone.
Nice to see you.
Good morning.
Good morning.
And I know Graham is there somewhere. So, and Eileen is as well. And Senator Sears, I'm sorry for interrupting, but just to address another issue, obviously the role of the Supreme Court has many administrative responsibilities. And because of those responsibilities, I think it's really important for any justice to have good management skills, because they'll be setting policy for the judiciary. And I think it's important to have a cohesive statement from the judiciary on behalf of all the courts. And you have to work collaboratively, I believe, to be able to achieve that consensus. And I do believe I work well with others.
Thank you. Other questions? Senator Benning, I think, is the first question.
Judge Waples, my face was smiling as Judge Zone introduced you because he was talking about dinner conversations. And I'm sorry you couldn't see the look on my face, because it brought me right back to the late 1960s, early 70s, when we were at the height of the Vietnam War. Mm-hmm. And none of my family was in the legal profession. They were middle-class people, and my father especially took the position of America, love it or leave it. And I spent some time having some conflict with him over that conversation. And as I was thinking about that whole scenario, I'm looking at your family now thinking, oh my God, what was the dinner conversation like around the table? That's probably a question for Lane, not you.
I'm sorry.
That's all right. I did want to make sure you knew two things. I am now the last practicing attorney in the legislature. I don't know if that'll change in the next election. But I am very happy to hear that you have two children that are coming into the legal profession. It is, for those of you who are her children, it is a noble profession. And you will get a lot of grief through the years about your profession, but always stand proud and do whatever you can to advance the cause for the legal profession. The second thing I wanted to tell you, Judge, is that the defense bar has a list serve. And all of us communicate regularly. And when your name was announced for this nomination, that list serve lit up like crazy in favor of your appointment. I just wanted to take that with you as you go forward and wish you the best.
Thank you, Senator. Thank you for those words of wisdom, and thank you for that kind encouragement. My two sons hope to make their way back to Vermont. They both worked in firms prior to going to law school as paralegals in Vermont, and it is their ultimate dream to make their way back home.
Great. I hope they always fight with their parents at the dinner table.
Senator.
If I may, Senator, yes, we learned how to argue well before I opened my first case.
That's great.
So I might have misheard, but I thought I heard Lane say that you were in a pre-law class, and I'm just wondering how many people in a pre-law class have ever been involved in the the confirmation of their parent to a Supreme Court. I think that that's probably making history.
No, definitely not too many. Fortunately, I'm a 3L, so I'm almost done with the journey.
Okay.
But it's the exact same thing. I'm sure it still stands. I don't think I have many colleagues and classmates who are sneaking out into the hallway to listen to their mom. It still stands.
The other thing I would say is, Judge Waples, I can see that your feet have not yet touched the ground.
I don't think it ever will.
I'll share that with many.
Yeah.
My wife. Yeah, my dinner table as a kid growing up sounds like very much like yours.
It's a great place to learn how to be a lawyer or a politician.
Yes. You have to survive that way.
Other questions for the judge?
I just want to say something to welcome you back to our committee, Judge Waples.
Thank you, Senator.
We were here on your initial start with the court system, well,
Yes.
as an official in it, and and I remember you saying something that your mother had told you was, no, don't let this go to your head.
That's right. My mother always said that when I was sworn in 7 years ago, she drove up through a snowstorm, and she and my father, and I was sworn in by Governor Shumlin, and my mother, I know, was enormously proud, but with the resolute immigrant attitude, she said to me, don't ever take yourself too seriously because you work for the people and you do not let them down. So those are words I've heeded every day. And sometimes, and I'm not infallible, and sometimes I fail, but it's not due to lack of interest or hard work. It's a mistake I've made, but I am devoted to the citizens of this state. I am devoted to upholding my oath and serving.
Thank you.
Great.
Thank you very much. Are there any other questions for Judge Waples? I think what we're going to do now, and you may stay on the Zoom, we're going to have a vote, although we'll hold it open for Judge or Senator Bruce,
Yeah.
who is unable to be here right now. I don't know
Okay.
if he is. Is there a motion to report favorably, Justice Waples?
I'd be honored to make a motion to report Judge Waples favorably and confirm her appointment.
Senator Nitka has moved that we report favorably on the nomination of Judge Waples. I'm sorry, Judge Waples, to the Vermont Supreme Court as an Associate Justice of the Supreme Court. Is there any further discussion?
Give me a second.
No. Senator, excuse me, Maggie, would you please call the roll?
Senator Benning,
Yes.
Senator Nika,
Yes.
Senator White,
Yes, enthusiastically.
Senator Sears.
Yes, enthusiastically as well, and thank you so much.
Thank you so much. I'm so honored. Thank you.
Thank you.
Thank you. My feet will never touch the ground, I'm certain.
Well, I think the vote will actually come in the Senate about a week from today.
Okay, all right. Thank you. Thank you for that guidance. All right, thank you.
Thank you.
Thank you so much.
Okay,
Bye.
Who would like?
bye. Thank you.
Thank you.
I think you should.
Unless you don't
want to.
I'm happy to have Alice make it.
Oh, okay.
I would love to.
Yeah.
Alice, as
with John for just a second.
Okay.
Alice has the
Oh,
long time on
Yeah.
judicial retention,
good.
long
Yes.
time member of this committee. Appropriate for you to do it, Alice.
That'd be very nice. I'd like to.
Yeah, yeah.
I
I would ask, though, that when we do it, we have a roll call vote.
Oh, yeah,
Senate.
you want to.
Yes, the Supreme Court justice.
Yes, that requires it, right? We are
It
live.
doesn't
Yeah.
require.
Yeah.
It requires a report, but it doesn't require.
It doesn't.
We should go live.
We are live.
Oh, we are live.
Yes, I loved her.
After Senator Benning just stepped out for a second, but I'll just give you a little preamble. After a lot of discussion back and forth over the weekend, it wasn't the weekend, the last few
Whenever it
days
was.
with them about the amendment and receiving emails from a number of opponents of the bill regarding clarity. Ben and I had a long conversation. If it was not clear, how to make it clearer. I thought it was clear the way it was done, but Ben has excellent work. And you sent me an email that Commissioner Sherling had said there was some about it. So we're trying to make sure that there's not confusion. So this would strike out section A, which was the codifying of Zulo, certain lieu thereof, these two amendments. So I'm going to ask them to go over it, and then there's a third amendment, which is something that we already have on the calendar.
So this one was exactly like the.
Well, I'll let Ben.
Yeah, I'm just gonna join with video so I can share my screen.
I'll just share it right now.
Oh, you got it? Okay.
Yeah, I got it. I'll
Is
just-
it this that you just passed up, Peggy?
Yeah.
Yes.
Okay, Ben Dobrogoski for the Office of Legislative Counsel. To your point, Senator White, subsection, so this is which will be fashioned as a floor amendment to the report of the committee on S-254. It contains 3 instances of amendment, 2 that are more significant. The third is really just more housekeeping than anything else. But as Senator Sears alluded to, there was discussion about how to make this clearer and really to give it the full force and effect that the committee had intended when it voted it out. So with that in mind, subsection A of the report that was voted out is now replaced to read as, it is the intent of the General Assembly to codify the common law principle for a plaintiff seeking damages for an alleged violation of Article 11 of the Vermont Constitution as established by the Vermont Supreme Court's decision in Zulo v. State 2019 VT1 and apply it uniformly as a burden that a plaintiff must prove to recover damages in an action brought against any Vermont law enforcement agency alleging a violation of Article 11. So this is a slight change in the sense that it adds some language about it being a common law principle, so judge-made law, and just sort of some reformatting to really make clear that this principle was established in Zulo, but the intent is to make sure it applies uniformly to any law enforcement agency. And I think the clarification was necessary after consultation with the senator, also with colleagues in ledge counsel, and based on some other statutory construction that already exists for consistency and really to provide the intent of what the committee was trying to do, which is this standard existed, but there was the open question over whether or not it extended beyond state police. And since that was the standard outlined in the Zulu case, it's just saying that this standard that was established there now applies uniformly to any Vermont law enforcement agency. The second instance of amendment would add a new subsection B, which actually enumerates the standard itself. It's almost a verbatim recitation from the Zulu case. And this was necessary really to give it true statutory effect and the full enforcement effect of law. And it goes beyond just intent. And it's sort of a belt and suspenders standpoint to make sure that this truly will be what's applied in cases involving law enforcement agencies for violations of Article 11. So it now reads, a plaintiff seeking damages against any Vermont law enforcement agency directly under Article 11 of the Vermont Constitution, based on a law enforcement officer's alleged violation of that constitutional provision, must show that, 1, the law enforcement officer committed a violation of Article 11 of the Vermont Constitution. 2, there is no meaningful alternative in the context of the particular case. And 3, the law enforcement officer knew or should have known that the officer violated clearly established law or the officer acted in bad faith. That is taken almost verbatim from section 55 of the Zulu decision, just with some changes for context and to effectuate the committee's intent to apply to any law enforcement agency. Third is some clarification in section 2 on the report that would be commissioned to ensure that it is confined to a legal analysis and shall not make any policy recommendations. The remaining changes are just to ensure lettering is consistent with the changes, and that also that there's a new title of the bill to read an act relating to recovering damages for Article 11 violations by law enforcement and a report on qualified immunity.
Next question.
Yeah, before you do, before I get to work, we print up report on that. What you just said, and maybe if you can bring it up. So it's an explanation of what we just talked about.
Is it on the party maybe?
I hope so.
Well, I have a report ready, but
Oh, okay,
yeah.
Then that should do it. Go ahead, you had questions, Al?
I just want to know, could you talk a little bit about number 2 at the top of the page, no meaningful alternative in the context of this particular case? Could you just elaborate on that?
Sure, and again, that is taken directly from the case itself, but this can mean really a multitude of things. So, you know, there's the concept that we had talked about, for Vermont compared to the United States, they're their own sovereigns. So an Article 4 violation of the Vermont Constitution is, there's Article 4 and the equivalent, it's the search and seizure provision of Article 11 in Vermont. It's to show that Vermont courts have the ability to remedy Article 11 violations because Article 11 is more expansive than Article 4, or than the Fourth Amendment. And so bringing a case in federal court for a Fourth Amendment violation may not always provide a meaningful remedy to one that's violative of Article 11. There could also be other remedies if there's a criminal case ongoing, where if a motion to suppress evidence is granted in that case, it may provide the plaintiff in a civil action the relief that they're looking for, because it would toss out the evidence and it may sink the criminal case, so to speak. And so it's really a contextual analysis in the particular case to see if there are other remedies possible that don't necessitate damages. So like I said, it could be a motion to suppress. It could be even injunctive relief to say that, you know, a law enforcement agency can't pull cars over for having obscured registration stickers, because maybe that would prevent the type of behavior that occurred in that case. So it would be an analysis to say that those other remedies don't exist or aren't available or don't provide meaningful relief. And so damages is really the way to go.
So, since Senator Baruth's not here, we need to change it to Sears, and if Wade is okay.
Yeah, don't put me on.
Okay, just me then.
But. No, I'll be on the amendment. I still, having still have concerns about the whole bill, but.
Well, Senator White, if there's any questions about the additional language that I can answer.
No, it's better.
Yeah, I think this is a good amendment.
Yeah,
I agree.
yeah. Well, maybe you guys want to be on the amendment too?
I don't want to go that far.
Okay.
I will say that the majority of the committee supports the amendment, not necessarily the bill.
Yeah, that's a fair
That would be a good thing to
characterization.
say.
You're moving in the right direction. What I'm afraid of is how this is going to look when it comes back from the other body. Same conversation we've had already.
Well,
Yeah,
there's always a conference committee, and I haven't even gotten that far yet. Yeah, I've got it out of the, I don't even know if the votes are there
You mean on our floor? On our floor?
on our floor.
are you kidding?
They've been taking counts, and I think they have 17, but that's close.
So Senator Sears.
Especially if Philip isn't there?
Yeah,
Did I hear from?
No.
I looked at my phone. I didn't-
I'm wondering, yesterday he called me at 9 AM. I was on my way up and said, aren't we meeting? And he
Well,
may
maybe.
not have realized we're meeting at 10 today.
I thought we were just doing Judge Waples and figured we could skip that conversation.
Senator Sears, so just for clarification, Senator Benning, Senator Nika, do you want to be a part of the amendment or?
No, I don't want my name on it. I will vote for the amendment, get it out.
Okay,
Yeah, I don't want to.
so just Senator Sears and Senator White.
And again, if you've got the report already, that's fine.
Yeah, the report is really the full report. It's not specific to this amendment
Well,
itself.
I need what you just said. And I've written it down on my notes, but I also need a clean copy for John Bloomer.
Right, well, I will go right back. I will change the who's moving for the amendment, and I will do a quick write-up and have it delivered to you.
Okay. Email it to me and I'll give it to you.
Okay, great, thank you.
And do the report triple space, please.
Sure.
You know, Becky Wasserman sent me the report that the thing that I did yesterday,
No.
and the print was about an 8-point font.
Yeah.
I could not read it.
I do 16-point font, but I don't triple space, so I
Appreciate
will.
It was so tiny, I couldn't read it.
Is that right?
You know, for the life of me, when Randy Brock asked me about the civil with Judge Zone, I could not remember. We did get the verbatim. And the reason I couldn't remember it was so quick. He said, he was not an active participant at the hearings. At the very end, he jumped on the camera and said, I can just tell you that it's a policy determination, the legislature determined where you're going to go with a non-unanimous or unanimous. I sent out S-178, original iteration to a number of judges who did civil work. No judges reviewed that and said that they agree that we should have non-unanimous verdicts. The judges who received that, active judges right now, their view was we should stay with unanimous verdicts. We've heard the policy arguments back and forth. I'm not going to repeat them here. I know that some of the judges from Ramos case that has been referenced today, as well as other studies. I won't get into that. You've heard a lot about that when you're going to make the policy decision. As far as the judges today, I did not hear any judges who received or refused that, who are doing civil work, indicate they believe that we should go to non-unanimous verdicts. That being said, if the legislature decides to go in that direction, I would go with the higher numbers of the supermajority. I would recommend that.
Are you gonna read that on the board today?
Well, and Brandy asked what he
No,
said.
let me tell you why that came up initially. We had a caucus. We always in our caucus go around in circles saying, what do you got in the committee and what's your vote on it? Blah, blah, blah. So when this particular bill came up, they asked me why I voted against it. And I said, for two reasons. One is I think the report, being 20 years old, could use some updating. The other is that Judge Zone told us that all the judges had reported back to him and said, it's fine, just leave it to be unanimous. And so he had that in his head since our caucus, which is why he got up and asked you on the floor if there was a survey of the judges done. But I think that will go a long way.
Yeah. Yeah. Read it.
Well, I mean, he basically said, none of them said that, I don't know what,
Well, some of them didn't even
I'm not gonna
respond,
judge
and-
what they actually said, that some of them didn't respond, some of them,
Which
those that
one?
did said they were fine with the system the way it is.
Yeah.
Right.
Let me know when I should go offline.
Oh.